The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
Good morning and welcome back to First Mover. The SEC said in a court filing that the regulator will file an interlocutory appeal of a judge's ruling on Ripple's programmatic sales of XRP. Joining us now to discuss is Michael Selig, counsel at law firm Willkie Farr and Gallagher. Welcome to the show, Michael.
Good to be here.
All right, walk us through what's going on here. I think that we were all expecting this appeal to come. What are some of the key takeaways?
Yeah, it was expected. You know, it's a game of chess here, so it's always hard to say, but many in the industry saw it coming. Essentially, what's happening here is that there's still more to the Ripple case that needs to be going to trial. And so there are these aiding and abetting claims, and there are also remedies in terms of what the penalties essentially will be for the violations. Because if you remember, the court did find that there were securities transactions in the case of the institutional sales. And so all of that would still be going to trial. What the SEC wants here is an appeal with respect to the judge's ruling on the programmatic sales, which were the sales on exchanges and blind transactions, which people have been characterizing as the retail transactions, and then the distributions to employees and other grant recipients. The court had found that those were not securities transactions. And so the SEC wants to appeal those points. And they're really focused on the district court split, if you will. We had the Rakoff decision in Terraform a few weeks ago, and we've also had a number of other cases that are kind of citing to that. So there's the Mashinsky action, and that case has been referenced there. So there's really this dispute, and the dispute comes down to whether you should separate out the token, which both courts agree is not in and of itself a standalone security or an investment contract. But the Rakoff court essentially has said that you can't separate out the token from the economic reality of the protocols and other facts. And so it in a sense kind of represents the investment contract. And there's some case law supporting this. It's a bit of a dispute as to what extent that holds. You know, if you take out certain facts, does that change the analysis with respect to the token itself? But the key issue is going to be whether the analysis around the transactions that were separated out by Judge Torres was correct. And in particular, whether the third prong of the Howey test, the expectation of profits based on the efforts of others, whether that really is satisfied with respect to these programmatic sales, and then whether an investment of money, another prong of the Howey test, was satisfied with respect to the distributions to employees. And if the court, the appellate court, were to take this interlocutory appeal up and decides that those prongs were not satisfied, it goes back down on remand to Judge Torres, and she could very well determine that other prongs of the Howey test are not satisfied. So this could be going back and forth for a bit. It's not necessarily going to result in XRP being deemed to be security in all instances.
So, Mike, nice to see you, by the way, but let's just zoom out for a moment. Like, what do you think is going to happen here, right? Because there were basically two reactions to the first decision, right? There was sort of like the Ripple people, and then various parts of the crypto were like, yay, it's great, we won. And then there was like a whole other camp that was like, oh no, like, we didn't win, there's a lot more to come. So I guess the question is like, what do you think is going to happen? Like, what's your prognosis here?
I think it's possible that it goes back down on remand. You know, a lot of us have been really focused on this common enterprise prong for these programmatic sales. Even if there is a reasonable expectation of profits based on the efforts of others, there's no common relationship between Ripple and the purchasers. And so it's going to be really tough, in my view, to get past that. And so I do think XRP ultimately is still deemed in these types of transactions to be a non-security, but it very well may go back and forth and go up to the Supreme Court. I think on the actual distributions to employees, the SEC itself and guidance is kind kind of taken the view when there's no bargained for consideration, so that the persons that on the employee side are not contributing to an employee benefit plan, for example, and receiving tokens or securities, that's typically not deemed to be a contribution of tangible and definable consideration. So I think it's going to be hard as well for the SEC to backtrack on prior positions that it's taken, and also it's not necessarily really clear in any case law. So I do think that issue actually could go in favor of Ripple right away. But the programmatic sales, it's a trickier issue, just in that I think other prongs of Howey really should be analyzed in that case.
Michael, this partial win has already been referenced in other cases. I think Coinbase most recently referenced this in one of their responses to the SEC. How might the appeal affect all of these other cases that are now using this as part of their arguments against various different regulatory bodies?
The biggest impact is going to be on Coinbase and Binance. Whether this appeal goes one way or the other, it's going to take a while. And so I don't know the timing is going to be important here. Coinbase just filed its motion to dismiss a few weeks ago or last week. And so that's going to be decided in the, near term, and likely before there's any sort of appeal here. And of course, we also have to have the Second Circuit grant the appeal. So who knows if there will even be an appeal. I think the decision in Coinbase is going to be important in terms of this motion to dismiss. If it goes Coinbase's way, that's going to be even more pressure against the SEC, because we've now had another court really erring on the side that these tokens aren't securities. There may be instances where they're sold as investment contracts, but the large majority of these transactions are not investment contracts. And I don't see a huge win for the SEC even on the appeal. I think this goes back down on remand, and Judge Torres has another opportunity to say that there's no common enterprise. Paul Graywall said essentially you can substitute any of the tokens in the Coinbase complaints for XRP, and really the analysis holds. So I think Coinbase will continue to make that analysis with respect to the full Howey test, and not just focusing on that one prong, and they have strong arguments there. So I don't think this actually, no matter which way it goes, is going to help the SEC here. I think Coinbase has all of the arguments it needs to say that these are not securities.
All right, Michael, we are going to have to leave it there. Thanks so much for joining the show. It was wonderful seeing you again.
You as well.
That was counsel at law firm Willkie Farr and Gallagher, Michael Selig.